Start. In light of these facts, it cannot be said that the appellant was denied opportunities to present her case or participate in the proceedings. The reluctance and consistent failure on the part of the appellant to partake in the proceedings and avail the numerous opportunities presented to her, would, in our opinion, not constitute a violation of the rule of odi alteram partem stop passage. Au contraire, the record demonstrates that she was afforded repeated opportunities over the relevant period. The learned trial court has examined the documents submitted by the appellant and found that the same do not justify the grant of any indulgence. We too have perused the medical documents on the basis of which the appellant is seeking relief and find that most of the documents do not pertain to the relevant dates on which the matter was listed. Passage. No party can be permitted to abuse the process of the court, thereby prolonging disposal and adding to the staggering pendency of cases. Such conduct not only exacerbates the frustration and angst of litigating parties but to our mind also contributes to an avoidable gradual erosion in the faith reposed upon the judicial system. The closure of the appellant's evidence was the natural concomitant of the repeated and consistent default on her part. The dismissal of the appellant's application to reopen evidence was, therefore, a proper exercise of discretion by the learned family court. Passage. As regards the contention that the appellant was denied the right to oral arguments, the order dated 11/1/2023 makes it clear that while the respondent's final arguments were heard, both parties were expressly granted liberty to file written submission. Despite this opportunity, as the record reflects, the appellant failed to file even her written submission. Passage. It is imperative to underscore that matrimonial disputes are intended by law to be resolved with utmost expedition. Prolonged pendency, extending over more than a decade as in the present case, not only frustrates the purpose of the litigation but also defeats the very object for which section 21B was inserted into the Hindu Marriage Act by the 1976 amendment and subsequently reinforced by the enactment of the FC Act. Both legislations unequivocally mandate that matrimonial disputes must not be permitted to drag on indefinitely. This legislative command reflects the social necessity for timely adjudication in matters concerning marriage and family. Section 21B of the HMA reads as follows. Over.